G'day friends and foes, Arjay Martin here, and this is TINLA episode 34. Well, this is not legal advice for short. So this is just a quick video, and I have to be careful of what I say in it due to the nature of what the video is about. So the video is about just a quick update as to what is happening with the COVID directions court case that I have in the Queensland District Court. So a lot of people like, seeing documents to make sure things are legit. So there's District Court of Queensland. It's probably backwards on your screen, perhaps. Or maybe it's mirror imaged or whatever. So I have a mention on the 31st of July, and it's at a time to be decided at the Southport District Court, and it's got the little court seal on there and whatever as well. There's a notice of intention to appeal. I have to cover some details on there, of course. So basically, a summary of what it's about is probably back in April, I set up a bunch of protests that were to last, basically until at least the election in Queensland. And they were weekly protests. That includes in other states and territories, but focusing on Queensland just because, if the COVID restrictions, it's very hard to travel. I also didn't have a vehicle that was working at the time, which now I do. Woo. But anyway, so then as a part of that, one of the protest locations that were added was Surfers Paradise, and that was supposed to start on the 29th of May from memory. And I put in an authorised protest application with the Queensland Police, and that was rejected for the Surfers Paradise protest, despite the fact that the very next day after the trial that was in the magistrates court, that I had an authorised protest in Brisbane. So, we have this magical virus, COVID-19, or coronavirus SARS-2, and it knows not to spread in Brisbane, where I was allowed to have authorised protests, but if it was held in Surfers Paradise, then, everyone would get sick and die. It's just like, this magical coronavirus doesn't spread in Coles and Woolworths and Bunnings and these mega stores, yet it apparently knows only to spread in mum and pop shops that are closed because they aren't essential businesses, that kind of thing. Anyway, so the police opposed that application and it went to court. Then the magistrate very quickly went through the application and erred in law, I submit, and he claimed that there was a threshold issue. And hi Brian. So Brian says Melbourne Shrine we joined and then nothing. Yeah, so besides there's the purported Black Lives Matter outbreak, as in the protests they had, then, people went to Melbourne Shrine, people went to Rundle Mall in Adelaide, people went to all these other places, and there weren't outbreaks. But anyway, with the magistrate, he quickly went through the application and claimed that the fields that were answered, which there were two of them, as unknown. So basically you get a 2-page sheet and you fill it out with your proposed political rally, protest, whatever you want to call it, peaceful assembly, and you have certain fields in there. So just say if you have a procession or a march, then part of that is what are the proposed, and it's only proposed, it doesn't have to be obligatory, that if someone puts an answer for that they have to follow that, but propose stopping locations and stopping times. And I put unknown for 2 of those answers, which a one-word answer is, of course, the answer. And the judge claimed that because it's a non-answer, and this is very paraphrased, that there was a threshold issue, a standing issue, so therefore this is one of the places where he buggered it up, I submit. So he claimed that there was a standing issue or a threshold issue, i.e. the court didn't have jurisdiction to hear the matter, but then he accepted that application as opposed to dismissed it. There was a police application, not my own application, and that's one way that I submit the magistrate erred in law. And there's other components too, which as I said, I've got this notice of appeal that should be amended a little bit, and I'm hoping to do that soon. And also some other material things are that I have been speaking with a barrister and a solicitor. They're not engaged at this moment because there's particularly an issue with such a short time frame, but I did apply for an adjournment, which the adjournment application will be heard on the 31st as a part of the mention. So hopefully that is granted, so therefore hopefully we can get a barrister and solicitor on board, and they're experts, particularly barristers, in evidence law as well as procedural law. A lot of Tom, Dick and Harry's can look up, i.e. normal lay people can look up the substantive laws, like X, Y, Z means ABC or whatever, but a lot aren't experts in the procedural aspects. So that can make or break a case. Yeah, so Bronwyn said it's a specialised area. That's exactly right. That's why barristers generally cost big bucks, so to speak. So do you have any quick questions, anyone that's watching at the moment? I'll just wait for any responses. And of course, as I said before, I have to be careful what I say as a part of this. It is before the courts. You get to see my fluffy hair illuminated by the car. Yeah, so Brian, so I can, try and do the whole case myself. That's fine, but it is, particularly helpful to have specialists in terms of procedural law, in terms of evidence law, that kind of thing. Then also, I also have other things that I am doing in life as well. So, I ideally would be able to concentrate on one thing at a time, but unfortunately I can't do that at this stage, because it's like, if you have a factory, if you make cars, you may be able to make one car yourself per month or whatever, but yeah, so I'll get into that in a second. So you might be able to make one car yourself per month, but if you have a factory of people and they all specialise, this is Johnny, he puts the wheels on, Sarah puts a motor in, all that kind of thing, then, you can be a lot more effective. So Brian's asking about financial support. So basically there is a risk besides any costs that I incur myself, which I've already had filing costs as an example, but there is basically, trying to work out the best way to put it or whatever, but the real risk is that with me, running the case, that should I lose, then there might well be costs in the tens of thousands of dollars basically put against me. So that's not the greatest aspect or prospect or whatever you call it, but it is what it is. And if I don't do it, who else will do it? And I, for instance, am, as far as I know, the only person who worked out that in Queensland that the COVID directions are not law and for actual lawful reasons. So under section 47 and you got sections 47, 49 and 52, the important parts of the Statutory Instruments Act of 1992 from memory, in Queensland state that all exempt subordinate legislation, and that's legislation not made by the Parliamentary Council, must be gazetted, and that hasn't occurred. So until that occurs, that the COVID directions in Queensland, I submit, are not even operative. So even you've got the constitutional arguments, as in, should the law be allowed to, go against things like, the implied right to political communication or closed borders in terms of, the Commonwealth Constitution, or discrimination of residents from one state to another state, or even mandatory vaccination in terms of, the federal government or the government may provide, it's actually concurrent power in section 51 subsection 23A, but the government can provide medical and dental services so long as it does not constitute civil conscription, as an example. So there's some of the constitutional arguments, but even without the constitutional arguments, I submit that the COVID directions, for Queensland at least, are not law and not operative, have not yet commenced, because they have not been gazetted. So that's section 47 of the Statutory Instruments Act, 1992, Queensland. And then you have section 49 that states that these directions, or this exempted subordinate legislation, or subordinate legislation generally, must be tabled in Parliament within 14 days. That apparently, again, has not occurred. And section 52 basically states that if there is a law or a purported law that says, hey, look, you don't have to gazette or notify, it's actually technically called notification via the gazette, the exempted subordinate legislation, then that is inoperative in itself, because it all must be notified by being published in the Queensland Government Gazette. I have gone through searching for particular terms within the Gazette from November last year until yesterday, because they come out with them weekly generally, as long as Parliament's sitting. And some of these terms are COVID, gene, short for GNet Young, and I'll say why in a second, and young as an example, and no relevant entries were found by myself. I'm happy for others to check my work, and if I'm incorrect in that, inform me please. But the reason for those particular terms being searched is that with the Government Gazette, and if anyone has read any of these COVID directions, there's different ones. There's ones on like movement and home confinement, then there's one on the banning of, just wait till the car goes past, of hydrochloroquine cannot be prescribed for COVID, which may not be the case anymore, because they were going to do some trials in Australia for that. Just clicking a button. Then in a Gazette it should say, as it says on the direction, something like, I, Dr. Jeanette Young, Chief Health Officer, Chief Medical Officer, depending on terminology in Queensland, I think it's Health Officer here, do hereby declare blah blah blah, because of COVID-19, blah, blah, blah. So if those terms aren't in those gazettes, then it has not been gazetted or notified. I submit, and I purposefully have to say I submit multiple times, and as I said, this is still before the courts, still yet to be determined, and it was, in a way, doing it this way, or me going out and getting a fine and then trying to challenge the COVID directions that way, which, potentially I might well have to do. If you know anyone in Queensland that is also a reasonable person and sane and whatever that has a COVID fine, please ask them to contact me. And I won't provide any legal legal advice to them or whatever, but if they watch this video, then they might well want to add a couple of points. Anyway, so I do intend on making a GoFundMe page, because that way, you have transparency, people know exactly how much is being raised, that kind of thing. And basically, the purpose of it is to mitigate, if you want to call it that, or lessen the risk of me basically being made bankrupt. I'm doing this to, among other things, help everyone. And if Queensland falls in terms of these COVID directions, then the other states and territories, I don't know if you heard that, but other states and territories may well follow. Each state and territory is slightly different, though, in terms of, there's some states where the chief health officer / chief medical officer makes these directions. There's other states, such as Western Australia and South Australia, from memory, where police actually make the directions or purported directions, such as Grantley Stevens in South Australia as an example. So he's a police commissioner, as well as he has, special titles as, I can't think off the top of my head, but it's like, he's in charge of emergencies in South Australia. So with the, potential risk of, maybe losing tens of thousands of dollars, maybe even more, then it would be very helpful if people could contribute from right around Australia, or there's Ross, long time no see. But there is what was I saying? So basically, if I was to lose, then I might well receive cost orders against me. I'd argue that, it is in a public interest, the case, so therefore the costs, if any are awarded, should be borne by the Queensland government. But, it is what it is, and with the potential reward of, the government being basically made to follow the law, as they should, of course, but, that has certain rewards for people, the opening up of the economy, that kind of thing, then, you've got to balance that with the risk, which basically I'm bearing all the risk of having these costs awarded against me. Cherie says, surely they wouldn't make someone like you pay cost. Well, if they do have the opportunity to do that, and if the judge agrees that costs can be awarded, then I'm sure that they would want to make me pay costs, because that way they basically get rid of me. For instance, I'd no longer be able to run in federal elections if I was bankrupted by this. And then, it also discourages others from challenging ultra vires or beyond power actions by the government. So, I have requested of the Queensland Police Service if they, by consent, can agree that each party bears their own costs, no matter their outcome. That is also a part of the Peaceful Assembly Act, which is the originating legislation or jurisdiction that the police sergeant has opposed my battery's about to die, I think. Opposed my authorised protest. So part of that, I think it from memory, is section 16, subsection 3, maybe. That for the magistrates' court, at least, that each party bears their own costs. And then, what's that about Bernard Gaynor, Brian? Anything's possible, Cherie, but it isn't actually a tribunal. It's the district court. And the police are trying to get it sent to directly to the Supreme Court, which of course just increases costs and whatever. And I have to put a big asterisk next to that if that is even able to be done. But again, I can't discuss that in this video. So if you wouldn't mind explaining what you mean, Brian, with Bernard Gaynor in case part, like you suggest I contact him and ask him for some tips or something. Oh, okay. I thought his troubles were over. So Bernard Gaynor, for those of you that don't know, was being continually sued by someone. Apparently, this is very paraphrased. Take it with a grain of salt, in tribunals for anti-discrimination, for him challenging the army, basically engaging in political activities. Yeah, so with the point of law, part of what I'm seeking is a declaration that and it's important to realise these declarations aren't binding, but they're often followed by the government, but a declaration under the Human Rights Act 2019 of Queensland that at least for protesting and political rallies, the right to political communication, that COVID directions can't apply to that, or that the COVID directions are incompatible with human rights in Queensland. Just as an example. So, what else does anyone want to chat about? Otherwise, I can just bugger off. Like I said, I'll end up making a GoFundMe. I'm not sure when that will be up. Maybe tonight or tomorrow or something like that. Maybe I'll do another short video. Again, summarizing, this video is for people just joining. This video is about my notice of appeal, subject to leave, for it depends which way you want to look at it. So it challenges, among other things, the validity, as well as if it's even operable or not, the COVID directions. Ross is asking who the other party is. So that's a very good point. So I was sued personally by a police sergeant, and that's another error of law. So the Queensland Police Service, and all of this is what I'm saying is my submissions. So under the Peaceful Assembly Act 1992, Queensland, the Queensland Police can oppose or object to, if you want to look at it that way, an authorised protest, and that was not done in the name of the police. So as part of that act, a police sergeant or higher can bring about the action, but it has to be brought in my learned opinion, if you want to call it that, in the name of the Queensland Police Service, or QPS for short. That was not done. I was personally sued and opposed by a police sergeant. So it's suing as in saying, hey, look, you can't have this protest. So the order was that I could not protest on that particular day anywhere in the universe, basically. So again, that's a jurisdictional error or problem as well, I submit, because if I wanted to go south to New South Wales, then why should a Queensland magistrate be able to ban me from protesting on that particular day in New South Wales? And I submit that the police sergeant had no standing to even sue me to prevent the authorised peaceful protest in her name. So she could represent the Queensland Police Service, she could have, and put, Martin against, the QPS against Martin, but they didn't do that. She put her own name against myself. Yes, I have had matters at court before, Ross. How did you end up going with your issue or whatever that was a couple of months ago? Did you win or whatever? Or reserved decision, perhaps? So if Ross wants to answer, he can, but while he's typing, does anyone else have questions? And thank you, Cherie. Just try and scroll up and see if I missed any particular comments. And thank you to Brian, Lisa, Bronwyn, Ross, Cherie, and I think that's everyone that commented. Yeah, so it is very strange, Cherie. So I submit that they weren't allowed to do that. And with the magistrate, he said because... Sorry, just reading comments. Because I wrote unknown for 2 fields, that there was a threshold issue or a standing issue, but as I said, the police made the application, or a police officer who did not do it representing the police, but in her own capacity, and there were threshold issues, been other threshold issues, but that means that the case should have been dismissed. Don't be sorry for questions, Cherie. That's why I'm doing a live video, so people are updated, and you can ask questions. I can't answer everyone's questions, though, of course, if people ask particular things, because things are before the court and stuff like that. And Ross said he's in a court of appeal, so that's interesting, and let everyone know how you go with that. And just so people know my filing number, it's D195/20 in a district court. So D for district court. Woo. So the barrister and the lawyer aren't on board yet. We're still in preliminary discussions. One particular problem is the very short nature of, it's going to be in the court for mention on the 31st. And there's certain things that need to be done before that. Of course, should they take the matter on, they need to read up on all of the relevant law, read my submissions, edit things, amend the statement of claim, that kind of thing. All of that stuff takes time, and of course people don't want to jump on board last minute, and then, if things aren't in the fashion how they would like to argue things, or they might have particular expertise in certain things, and they think, oh gee, I remember this case happened, this happened, blah blah blah, then they don't want to join last minute, and then because it's arguing things a different way than they would have, then potentially lose, if that makes sense. Yeah, so hopefully they do an adjournment with the GoFundMe. How can I put it? So basically that needs to be successful in terms of getting some money available, which would be trust money in case of costs being awarded against me. And if costs weren't awarded against me, then that money would then be spent on other legal cases to do with the validity of certain laws, or COVID directions, that kind of thing. I'd like to do a High Court case, which I've been working on getting standing for as well. So, of course they may well amend grounds, and there's some other grounds that I want to add anyway that I was going to try and do as a separate case, but maybe I have to combine it all together. So basically, if people are generous in their donations, and I don't like asking for money, but it's required, then we can proceed, and I won't have that such a big risk of if $50,000, $100,000 or something like that gets awarded against me, but otherwise I can potentially not proceed with the case, and then try and get rid of the directions another way. So just a second. So I'm not a lawyer. I have studied some law. As many people know, I am not a lawyer. I do not purport to be a lawyer. And so Australian lawyer by definition has been someone that has this is a usual process of becoming a lawyer, done a law degree, either LLB or Juris Doctorate. Then on top of that, you either do articles, which no one ever does anymore apparently, or hardly anyone. It's like being someone's slave for 2 years apparently. Or alternatively doing practical legal training, and then you have as part of that a course component, as well as supervised practice. So it can be 75 days, or you can do an additional course to bring that down to 15 days, but then you're doing 2 months of course work extra anyway. And then you get a certificate, and then you take that to the Supreme Court, and then you have a swearing in ceremony. There's also some other components, but this is just a brief thing. And then once someone is admitted to practice as a solicitor or a barrister later on, you basically have to be a solicitor before you can become a barrister, unless you come from, say, a foreign jurisdiction or something like that. You might be an American attorney. They combine their barristers with their solicitors, but then you get admitted, and then you're an Australian lawyer for life, basically, even if you don't renew your practicing certificate. So the mention is on the 31st of July. The time is not yet decided, and it's at Southport Magistrates Court. With the COVID directions, the courts, if they're still applicable, in a week and a half, then the courts won't allow people that aren't parties in there, I would suggest. Because that's what happened last time with the magistrates court as well. So Zara, it may be that you might be referring to, arguments that the, like, I don't know, you can explain if you like, but it may be that you're, a lot of people have suggested that, the Queensland Police Service is a company, not the part of the government, that kind of thing. If you're referring to that, let me know. If not, then, that's fine too. Yeah, there's a good point, Brian, about COVID 1984. And, there's George Orwell's book 1984. There was also Aldous Huxley's, what was that called? Has a similar book, but Brave New World, about dystopian government, that kind of thing. Yes, Ross, 31st of July 2020 at the Southport District Court. So Zara, presumably again you are talking about like David Wynne Miller's stuff that has been taken up by the likes of Romley Stewart, i.e. that claims that basically people have a legal fiction, a straw man that they carry on their back, and that's represented by capital letters and all this other stuff. That is not actually the law, which I will make a TINLA video one day about. I do have more pressing things to make these videos about, and this battery is down to 5%. It's just gone really dark on the screen. So if things go south, it would be dismissed on those grounds. So on what grounds? So I can't really speak about other people's cases either. So Wayne has had many different cases, Wayne Glue. So how can I put that? So there were videos, so it's publicly, how can I put it nicely and succinctly and whatever. So there are some people that film cases or do little speeches after cases that basically they say, just say their name's John Smith, and the court calls for John Smith, and John Smith is in the room, and then just ignores it, and then the judge says, whatever, or there might be, John Smith goes into court and says, hey, look, I'm John Smith the person, I'm representing John Smith the straw man, the corporation, that kind of thing, and then they challenge the judge 3 times. It has to be 3 times for some magical reason, as to the I'm not contracting with you, this is Admiralty law, maritime law, I have 1 foot upon the land, 1 foot upon the sea, and then the judge gets pissed off and leaves the court, and then they just say, I am the highest authority in this court, case dismissed, and then they leave the court, and then go film a Facebook live video or YouTube live or whatever and say, hey, I just won this case because the judge ran away because I knew that he was, he was a fraudster, or whatever way you want to look at it, and then I dismiss the case myself. So that doesn't actually work, and I'm happy for people that have done that in a actual judge's court. So back in a day, even though magistrates are now classified as judges, then off certain legislation or whatever, so a court is constituted by a judge, and then it's got like asterisks, a magistrate is classed as a judge too. This is very, very paraphrased. But it used to be that magistrates weren't judges and judges were district court, Supreme Court, High Court. But if someone has successfully done it in a district court or above, then I'm happy to hear about that. There was also another lady at Southport Magistrates Court, I believe it was maybe a week ago, that did a similar video. And I don't know what her case was, and I am not purporting to give legal advice, as I keep saying. The whole point of it being called This Is Not Legal Advice. Even if I was admitted to practice as a lawyer, is that basically you got to cover yourself. Anyway, so that'll probably do, because this battery is going to die. I'm just trying to see. So it's got the red exclamation mark on a battery anyway. Please like, share, subscribe, that kind of thing. Follow this page. Share the video everywhere that you can, in all the groups that you can, because I believe that it is helpful to get the word out, so that hopefully many people can contribute to, as I said, the GoFundMe page, where the money is basically to indemnify me if I lose, so that if I get $100,000 awarded against me in costs, that if there's hopefully at least $100,000 to cover it, but that way I'm not screwed for the rest of my life, pretty much. But I'm happy to help people, but people also need to help themselves as well. And if everyone can contribute a little bit, if everyone in Australia contributed 10 cents, that's $2.5 million. And you can do a high court case for that. Even if you lose, you of course give it your best crack, but we can't ultimately determine what the court's going to come up with in their judgments. We can't anticipate them. We can suggest that the law is XYZ, or should be XYZ, but it's up to the courts to make their own determinations, that kind of things. And sometimes they make appealable decisions because of jurisdictional error, or they acted ultra vires or beyond their powers, or they erred in law, that kind of thing. Anyway, so I'll make another video tomorrow, I guess, or possibly the day after. It's better me to get this GoFundMe up and running ASAP, to see if we're going to continue to continue with the case. Otherwise, there is a option of basically abandoning the case and then copying whatever costs are already accrued, that kind of thing. But I'd rather not do that, and I'd rather help you to help yourselves and get rid of these ridiculous COVID directions that aren't even law. They're not even subordinate legislation, I submit, and I've given reasons why that is earlier in this video, as well as in several other TINLA videos. You've got like TINLA 16, which is references for some of the videos that I've made, claiming that I submit the COVID directions for Queensland are inoperable, invalid, that kind of thing. Anyway, thank you, and be well, stay awesome, and all that stuff. Thank you, bye.